Good morning. My name is Malcolm Neekirk. Welcome to Fretton's fourth coffee break briefing of 2024. It's April already, can't quite believe that. Just a couple of parish notices this morning. As I always do, I'll give you another reminder to try out the retention of title website tool I showed you last year. Why not scribble out a quick note to yourself to have a look at it at the end of this morning's presentation? And I'll remind you again that I do pre-pack evaluations. I've actually got, well, 5 I've done or am in the process of doing in the last month or two. I'll be very happy to give your buyer an estimate if you're selling to a connected party soon after your appointment as administrators. If there are any questions you'd like to ask during the presentation, please ask through the question box. I may pick them up as we go, but it's more likely today that I pick them up at the end. I hope to finish my presentation by 11 o'clock, but I may go on beyond that if I need to deal with questions. Okay, I think that's the housekeeping out of the way, so I will now start the presentation. So, good morning. I'm going to be talking about legal myths and old laws. Old laws, if you've been to my coffee break briefings before, you will know that I tend to pick up on old laws all the time. You regularly hear me talking about old stuff, and more than this morning, I think. And legal myths, well, this was originally planned for April Fool's Day. And then I was reminded that April Fool's Day this year was a bank holiday. So I put it back a couple of weeks, and here we are. But you occasionally get people telling you that there's all sorts of strange stories, and you're never quite sure whether they're true or not. And I'm going to take the opportunity this morning to look at some of those, look at the truth behind them. And although at first glance this may not seem terribly relevant to insolvency law and practice, I'm hoping that in the process of doing so, we'll be picking up on various issues that are actually relevant to legal issues that you may encounter in everyday practice. So let's see if we can get this started. Here's the list of topics. There are 9 that I'm hoping to cover. I won't bother reading all of those out to you, but I'll just move straight into the first one of those, and mince pies and Christmas. Are mince pies actually banned at Christmas? And spoiler alert, no, they're not. But this is the story that you will usually see someone publishing in December almost every year. The story is that a law was passed in 1642 that bans mince pies in Christmas, and it's never been repealed, with the implication being that therefore that law remains in force. Story behind it, I'll give you to that. In 1642, Parliament did impose a monthly nationwide feast. It applied on the last Wednesday of every month, and it was a proper fast. So amongst all of the other issues, the pubs themselves were closed last Wednesday of every month. 2 years later, Christmas Day coincided with the last Wednesday in December. Parliament offered no concessions, and everybody had to go to work on Christmas Day that year. The pubs were shut, and there were no mince pies in 1644. You can't imagine this happening these days, but Parliament, having done something that was incredibly unpopular, then doubled down on it 3 years later, and they decided to actually abolish all of the religious public holidays, including Christmas and Easter, and replace them with a statutory day off on the second Tuesday of every month. And this turned out to be incredibly unpopular, as perhaps you might imagine. A few years later, the monarchy was restored in 1660. Now, these ordinances passed by Parliament were never actually repealed, but they never had royal assent. So with the restoration of the monarchy, Britain again became a constitutional monarchy, and laws that had been, or purported laws that had been passed without royal assent, were treated as having had no legal effect. Now, pragmatically, they are regarded as actually having been the law from the time when they were passed until 1660. But after 1660, then laws, or purported laws passed without royal assent, had no legal effect. And of course, this is the reason, part of the reason why we still need royal assent on Acts of Parliament now, because we remain a constitutional monarchy, and the final step in the lawmaking process is for the monarch to give assent to the proposed legislation. Second one, is it safe for Welsh people to visit Chester? Now, why are we even asking this question? The answer, of course, is obviously it is, but now let's go back. But if you visit Chester and various other places, you will hear the tourist guide version of this particular piece of legislation, which is where they say that it is legal to shoot a Welshman with a longbow inside the city walls of Chester after midnight. Now, I'm not quite sure whether that is the Welshman has to be carrying a longbow for it to be legal for you to shoot him, or whether the only weapon with which you can legally shoot a Welshman is a longbow. Not quite sure about that. There are similar claims for other parts of the country as well. So it is also claimed to be dangerous for Welsh people to visit the Cathedral Close in Hereford, and for the Scots to visit the city of York. Now, the story behind this is that there was warfare between Wales and England in 1403, with Owen Glendower leading a rebellion for Welsh independence. And there may well have been a city ordinance passed in Chester in 1403, or there may not. There's no evidence that it did ever exist other than these myths. Nobody's been able to find the text of it. No copy of it exists. And even if it can be proven to have existed, in modern times, murder is a crime, and Welsh people, and indeed everybody in this country, has a right to life under Article 2 of the European Convention on Human Rights. And both of those modern laws would override any ancient city ordinance. So moving on from that, and again, it's a point that you sometimes see online, people suggesting that we don't need the European Convention on Human Rights. We can simply fall back on our ancient liberties conferred by Magna Carta. So what truth is there in that? It's worth, again, short answer, spoiler alert, it's not true, but it's worth having a look back at the history of Magna Carta to see what it was all about, and to give some idea of why people might possibly raise that as an issue. I'm just going to pause. I seem to have a question here. People are saying the slides are not advancing. Let's see if that's now working. Is that working now? Can you see the current slide now? Excellent. Thank you very much indeed, and my apologies for that. We seem to have had a bit of a mismatch between the what I was seeing on screen and what you were seeing. But I think we've got that sorted out now. So anyway, let's pick this up. We're talking about Magna Carta and just running through the history of Magna Carta here. Back in 1215, it was a peace treaty between King John and his barons. It really didn't last very long at all. Neither side kept to their side of the obligations. And within 3 months of it being signed, King John had persuaded the Pope to have it annulled. Interesting to see that the Pope then was regarded as having higher sovereignty than the king or his barons and something like that. The following year, it was reissued by a new king, Henry III, but it wasn't reissued in its full form. It was, I think there were 3 or 4 clauses had been cut out of it then. It was then incorporated in what was known as the Lambeth Peace Treaty, and that was in 1217. And for the first time, it was then referred to as Magna Carta. It was repealed and reissued in 1225, and that happened more than once in the successive years, until it got to 1297, when it was again repealed and reissued once more. And it still exists, in as much as it does exist at all, in the form in which it was in 1297. It hasn't been reissued since then. Let's just make sure I can move the slides on now. Now, there's an awful lot that is claimed for Magna Carta. It comes with an awful lot of baggage about what it is supposed to have achieved. Among the things that it did do was it was probably an inspiration that helped to develop the Constitution of the United States and probably various other countries around the world as well. But in terms of its current force of law, well, it remained on the statute book until 1829, and then section 28 of it was repealed. And in the 140 years that followed that, which was the first time that, well, since 1215, it was the first time that part of it had been repealed. In the 140 years since then, most of the rest of Magna Carta has been repealed, most recently by the Statute Law Repeals Act of 1869. There are only 3 clauses that remain in force, and they have virtually no legal significance these days. They could be repealed at any time by any government that wished to do so. Now, compare that to the European Convention on Human Rights, which is binding upon the government in the sense that not only is the government bound by its obligations, but the government also cannot repeal or amend any part of the European Convention on Human Rights. And that's because it is an international treaty, and you cannot amend an international treaty unless the other contracting parties agree to the amendment of it. And this slide just summarizes some of the rights that are granted by the European Convention on Human Rights, which are in the main not included anywhere in the Magna Carta. When you visit London, if you get into a conversation with your cabbie, you may well find that they'll tell you that they are technically breaking the law because they don't have a bale of hay in the boot of their cab to feed their horse with. Now, sadly, for the cabbies who tell you that story, that's not true. And in fact, it never even was the law that they had to carry a bale of hay. There was a law in London that protected people's gardens and public parks and so on from being used by cabbies to graze their horses. They weren't allowed to do that. A cabbie who wanted to feed their horse while it was on duty could only do so if they fed them hay from their hands or corn from a bag. And that was in section 51 of the London Hackney Carriage Act 1831. That legislation was repealed in 1976. So to the extent that it was even halfway through, it no longer is, and there is no need for a black cab driver to carry a bale of hay to feed his horse, or indeed anything else to feed his horse. Another one that you will sometimes hear, again, this is sort of tourist misinformation offices that tend to promulgate this particular one, is the story that you will automatically get a state funeral if you die in Parliament. And that is not the case. And there are examples of people who have died in Parliament and have not been awarded a state funeral, such as, for example, Spencer Perceval, who you will probably recognise the name of as being the only Prime Minister to have been assassinated. He was actually shot in the lobby of the Commons. There is a bonus point here, which is that MPs are banned by law from wearing suits of armour in Parliament. And that is a very old piece of legislation, which is simply called a statute forbidding bearing of armour from 1313. And if ever you want to refer to the text of it, there it is. It's basically in Norman French, which makes it a little bit hard for it to be interpreted in the modern world. But apparently, in translation, it does ban the wearing of suits of armour in Parliament. One that's perhaps a bit more relevant to some of us: is it illegal to be drunk in the pub? And the answer to that, which may be a surprising one, is yes, it is. And this goes back to the Licensing Act of 1812, which makes it an offence to be found drunk in the street or a park or any other public place, whether it's a building or not, and also to be drunk in any licensed premises, which of course includes a pub. Section 12 of the Licensing Act of 1812 also makes it drunk to be an offence for you to be drunk in charge of a cow in the public highway as well. So you better watch out for that one as well. And Section 12 of the 1872 Licensing Act is still in force. That is still the law of England. Most of the licensing legislation is now contained in the Licensing Act 2003, and that does make it an offence for pub staff to sell alcohol to somebody who is drunk. It also makes it an offence for you as a patron of the pub to try and buy alcohol for somebody who is drunk. And it also makes it an offence if you do not leave a pub when you are drunk and asked to leave. Moving on the general theme of goodwill and merriment, is it illegal to go dressed as a police officer to a fancy dress party? Short answer is no, but be sensible about it. It is an offence if you pass yourself off as a police officer, or if you're so convincing that other people might think that you are a police officer. It's also an offence to have any police uniform in your possession, unless you've got a legitimate reason for doing so. So I suppose in summary, you should be okay at the party itself, but just do be sensible on the journey there and don't push your luck. The law on military uniforms actually is tougher. Now this applies only to British military uniforms, so this particular piece of legislation doesn't stop you from dressing up as a Nazi. There might be other good reasons why you don't dress up as a Nazi, but it is an offence to wear anything that looks like a British military uniform, unless you're actually going to be on stage in a play or it's part of a legitimate reenactment or something of that sort. I did promise you some old laws in all of this as well. So let's have a look and see what we can find out about what I think is the oldest insolvency law still in force in England and Wales. And I found one that goes back to the 13th century. So similar age to Magna Carta, and certainly older than the current version of Magna Carta, the 1297 version. And it's the Statute of Marlborough of 1267, which is currently known for legislative purposes as either the Distress Act 1267 or the Waste Act 1267, depending upon which bit you're looking at it. Now, there are only 4 sections of the Statute of Marlborough that are still in force. Sections 1, 4, and 15 regulate the law of distress, and they form the Distress Act 1267. The other section still in force is section 23, which deals with the tort of waste. That is known as the Waste Act 1267. Now, sections 4 and 15 are now largely duplicated in newer legislation, specifically the Tribunals, Courts and Enforcement Act 2007, which is the piece of legislation that set up the rules for commercial rent arrears recovery, which is the statutory procedure that replaced the previous law of distress. The Law Commission, which is a government body set up to review the workings of the law and to recommend changes to the law. The Law Commission has looked at the Statute of Marlborough to decide whether it should be repealed or not. They would have repealed sections 4 and 15 because they are largely duplicated in the 2007 Act, but they didn't do so because they were not confident they could actually get the repeals to synchronise with the new law coming into force. So they thought it was safer to have the old law, which is now effectively redundant, still running once the new law has come into force. But they will recommend its repeal, sections 4 and 15, at some point in the future. And that will probably be dealt with in a Statute Law Repeals Act, a piece of legislation that goes through Parliament when passed by legislation. That will then repeal those 2 sections. The Statute of Marlborough is not only probably the oldest piece of insolvency law that we've still got, but it is, I think, also the oldest statute in force in the UK. When I wrote this slide, I thought I'd found an older piece of legislation, but turns out I was wrong about that. So I think this is almost certainly the oldest statute still in force. Section 1, which is still in force and is actually still relevant, this criminalises two things. The first thing it criminalises is taking revenges. The second thing is it criminalises levying distress without legal authority. Now, I'm not quite sure what it means by taking revenges, but I think I've probably got a fairly good idea. 1267, England and Wales were very much Game of Thrones type places, with the country being ruled by the barons acting partly on authority from the crown and partly very much on the basis of their own local jurisdiction. And they ran the country very much on the basis of they had swordsmen in armour who were fit, well trained, and able to enforce their will. So I can imagine that the outlawing of taking of revenges was an attempt to say, if you've got a dispute with somebody, sort it out through the court. Do not use self-help, do not use force to do so. The second part of section 1 about criminalising taking distress without legal authority. Distress was then about seizing goods against an unpaid debt. Distress has now been put on a statutory footing and we normally come across it in the context of landlords levying commercial rent arrears recovery, but HMRC still has a statutory power to levy distress. And section 1 of the Statute of Marlborough is actually a big part of the reason why a creditor who is owed, let's say, £2,000 can't simply walk into the company's premises and uplift goods to the tune of £2,000 and take them away, because that would be an unlawful distraint, and that is a criminal offence under the Statute of Marlborough, Section 1 of the Distress Act 1267. So it's still an important part of the legal moratorium that protects the goods in the insolvent estate from creditors. Section 23 is worth mentioning. It's relevant in the context of landlord and tenant law, and it basically makes it a criminal offence for a tenant to wreck the joint. So a tenant who damages the landlord's premises could be guilty of the tort of waste. And a tort is a civil wrong that gives the right to seek compensation, monetary compensation. So the landlord could sue the tenant for waste in the county court or the high court to seek compensation for the damage that the tenant has done to the premises. Now, that doesn't normally happen in the 21st century because most modern leases contain repairing covenants, express contractual obligations on the tenant to keep the property in a good state of repair. And that would effectively be the landlord's remedy rather than the tort of waste. What the Statute of Marlborough does is it extends the tort of waste. So it's not just a civil offence, it's not just something that a landlord has a remedy against by seeking compensation against their tenant, but the landlord could actually have their tenant prosecuted for waste for the damage that they have done to the premises. The Law Commission did consider this for repeal, but they decided not to because there was a small risk that repealing the crime of waste might itself have unintended consequences with the tort of waste and might have undermined it. And they said the tort of waste is important still because it gives landlords the ability to reach beyond the original contracting parties to somebody who is not a party to the lease and seek compensation from them if the premises are damaged by the tenant or somebody else. And they specifically, the Law Commission specifically gave the example of a not too careful liquidator as somebody who might be at risk from the tort of waste. So I mentioned that. I didn't know anything about the tort of waste until I did the research for this presentation, and it turns out to be something which is itself relevant, despite the age of this piece of legislation, to liquidators and insolvency practitioners in the 21st century. Final thing I want to talk about is about freemen on the land, who you may or may not have come across. So what or who are freemen on the land? Well, the freemen on the land idea, it's nonsense. It's pseudo-legal nonsense. It's the legal equivalent of the Flat Earth Society. And the people who call themselves freemen on the land, in the main, have been conned. They've fallen victim of a conspiracy theory, and they believe stuff that simply is not true. The problem for you as insolvency practitioners is that some of them are determined and troublesome litigants, and although their arguments have always failed in court, some of them do not believe that until the point comes when they are in handcuffs being marched out to the van to be taken away to prison. And even then, they still believe that they are right and that the system is in some way corrupt, and they just need to try harder. These are some of the things that freemen on the land tend to believe. One of them is that they believe that their birth certificate has created a fictitious person. They think that the birth certificate is like the certificate of incorporation of a company, and that the name on the birth certificate is not them, but is this fictitious person that they refer to as a straw man. And they think that if they dissociate themselves from their birth certificate and their straw man, they can release themselves from the legal obligations on the artificial person created by the birth certificate. This is, of course, complete nonsense. But they think that if they change their name slightly, and if I were a freeman on the land, I might, for example, change my name to Malcolm, put a colon after that, and then say, of the family Neekirk. And I think that's enough to release you from legal obligations as if by magic. Related to that is the idea that the law is a contract. They're not bound by legal obligations unless they have consented to them. And they think that legalese is a genuine legal language, and that there are certain magical words that only need to be recited and that will have immediate legal effect. And they also think that other words are being used to trick them. So, for example, if you ask a freeman on the land, do you understand what I have just told you? They will say no, because they think that the word understand means to stand under, means to be bound by, and they think if they say, they acknowledge that they have understood what you have said, then they will be bound by what you have said. And by refusing to acknowledge that they understand what you say, they are not being bound by consent to what you've said. This is, of course, nonsense. They also think that Magna Carta is important, and they also think that the American Uniform Commercial Code is important. Again, because they've learned stuff from the internet, a lot of it comes from America, and so they recite various provisions from the Uniform Commercial Code, which they call the Universal Commercial Code. And they think that is part of maritime law, and they think that the English courts only apply maritime law, which overrides everything else, and common law, which also overrides everything else. Their idea of common law is different from every lawyer's idea of common law, as is their idea of maritime law, which is extremely confusing. And I think that originates from the fact that people talk about things like citizenship and the dock of the court, for example. Freemen on the land can be really troublesome. They can harass the people that you work with, claiming that they are personally responsible for compensating them. And there are some organizations in this country and overseas who have resorted to using civil and criminal proceedings to protect their employees from harassment by freemen on the land. And they will disrupt court proceedings because they think that their magic words will change the entire course of the court proceedings. And if it didn't work the first time, then they certainly need to try it again and again, because that's the way to make things that don't work. They can be vexatious litigants, and in fact in Canada, they've become such a problem that the courts there now presume that somebody who is running freemen on the land type arguments is doing so in bad faith, and risks being declared a vexatious litigant quite early in the proceedings. You have to remember, though, if you do come across them, that in amongst all of the nonsense, they might actually be accidentally making some good points, some valid points, and you do have to respect those and give them proper credit. So I'll give you some examples of nonsense from freemen on the land. During the COVID lockdowns, some of them put notices in the windows of their business premises claiming that Magna Carta exempted them from COVID restrictions. They used to like particularly to rely on Article 61 of Magna Carta 1215, which was actually one of the ones that was repealed when Magna Carta was reissued in 1216. So this really was nonsense piled upon nonsense. Some of them claim to have common law car insurance, which of course means that they are driving uninsured. Some of them refuse to pay council tax, and many of them have actually been sent to prison for doing that. And if you look at local authority web pages, you'll see that many of them have actually got explanations of how you have to pay your council tax even if you are a freeman on the land. I'll finish this slide just with a comment that I've seen from a criminal barrister with some experience of prosecuting freemen on the land. And they said, well, it's pretty much the same as a plea of guilty, except the prosecuting counsel gets paid the fee that they would have earned if it was actually going to trial. As far as prosecuting counsel is concerned, this is literally win-win for them. So those are the points that I wanted to cover. Just a quick run through. No, mince pies are not banned at Christmas. Yes, Welsh people can safely visit Chester and stay after midnight. No, Magna Carta cannot replace the European Convention on Human Rights. Lots of reasons. No, cabbies do not need to carry a bale of hay to feed their horse. No, you will not get a state parliament if you die in parliament. Yes, it is illegal to be drunk in the pub. You can go to a fancy dress party dressed as a police officer, but be careful. The oldest insolvency law still in force in England and Wales looks to be the Statute of Marlborough from 1267. And freemen on the land, what's all that about? It's basically nonsense. So I hope you've found this fun. Apologies for the technical difficulties part of the way through this. Second summary slide is just to pick up on some of the directly relevant points that we've covered here. So we've looked at how laws are made in England and Wales and the significance of royal assent in legislation going through Parliament. We've looked at the precedence between statutes and lesser legislation, which one takes priority. We've looked at limits on legislative sovereignty of British government. We've gone back to look at some of the oldest legislation that is still in force, and we've looked a bit at the role and function of the Law Commission in lawmaking. And in terms of insolvency law and practice, we've touched on the law of distress. We've looked at the tort of waste, and we've come away with a warning about freemen on the land and the red lights that should be flashing if you see somebody running those sorts of arguments against you. So with that, I'm happy to take any more questions if there are any. If you have a favorite legal myth that you want to ask me now, I will do my best to try and answer it. And I do apologize for the technical difficulties earlier. still not entirely sure what was causing them, but we did at least manage to find a solution for them. And I'll just tell you now about some of the dates coming up. I'm intending to go to the R3 Technical Breakfast at St Mary's Stadium, Southampton, tomorrow, and the talk there is going to be about mediation. Sorry, we've got a question now. Jonathan Baker has asked, what is the definition of drunk under the Act? How drunk do you have to be? It's a great question, and I don't think there is a statutory definition of drunk for these purposes. Now, I understand that in the Royal Navy they have a functional definition of drunk, which is it's very binary, and it's have you been drinking, and if you have been drinking, are you still able to perform your functions? And if you are not, you're drunk. If you can, you're not drunk. And I suspect it's going to be something rather like that in terms of, are you drunk in a pub? If you are drunk and you're just sitting in a corner, quietly minding your own business, perhaps falling asleep, that's probably not drunk. But if you are being rowdy and disruptive, then I think you would be regarded as being drunk, and that would itself be an offence, as well as anything for any further offences that you might commit. Being drunk in a pub is a strict liability offence. You commit it simply by being drunk, whether you know that you are drunk or not. And in that sense, it is possibly still a useful piece of legislation. Anyway, moving back to the diary dates, I also mentioned the Southwestern Conference being held in Exeter. I'm not involved in that. It's David Kirk is organising that. There's his email address there if you want further details about it. It looks like it's got a good programme and some good speakers at it. I will be presenting at the SESCA seminar at Denby's Vineyard near Dorking on the 23rd of May. There is an R3 regional meeting on the 6th of June in Reading. And most importantly, there is the Fretton's Insolvency Conference on the 7th of June at the Barmer Lawn Hotel, Brockenhurst. Remember, it is an offence to be drunk in charge of a cow. And then later in the year, I'll also be at the SESCA Conference, Reading University in September, and the SESCA seminar in Denby's on the 10th of October. So with that, that's all I have to say. So thank you all very much for attending this morning. Next month's coffee break briefing is going to be on the changes to Companies House and the regulations applying there. There's a significant tightening up at Companies House to try and ensure that information being filed is more reliable than it is at present. And there are some important implications for insolvency practitioners with that. And I'll be covering the implications for insolvency practitioners next month at the May coffee break briefing. So hope to see you all then. Thank you all very much, and goodbye.